So if a judge thinks that you seem angry or anxious or defensive in court, it can really dramatically affect the outcome of your case. So today we're here to talk about how changing the way that the judge sees you can help you get a better outcome for your divorce. I'm Rachel Sloan. This video is part of the new Divorce Lawyer Q&A segment of my channel. And joining me today to talk about the psychological preparation you can do for your divorce case is Jessica Brylo. Jessica is the owner and lead consultant at Trial Dynamics, which is a company that's committed to helping you prepare for your case and get the best outcome you can achieve. Jessica has both her JD and her master's in psychology from Duke Law, and she's known for her short-term miracles, or her ability to help somebody change the way they show up in court after just a couple hours of work. Jessica, thank you so much for being here with me.
Thanks for having me.
Jessica, I'd love to start with, you help your clients change the way the judge sees them in court. And one of the ways you do that is you teach them some things about psychology. What's something that you teach your clients that surprises them?
So the thing that I hear the most often that I get feedback on that surprises most people is that if opposing counsel is coming at you as the client and you feel like you're being attacked, that it's actually good for your case. And so I teach people to try to change how they feel about that situation. If there is somebody who is attacking you, it's a human nature to try to balance things and make things to get justice in the world. So, if you're on the street and somebody is being attacked, your inclination is, I have to jump in and save them, or I better call 911 so somebody can save them. If you feel like there's already a couple people there that are helping out and that somebody's pulling that attacker off, then you can walk about your day because justice has been served. Somebody's taking care of it.
Okay.
So it's the same thing in the courtroom. So if you as a client are being attacked, or you as the attorney and client's being attacked, you want to sort of take a step back and still remain neutral. The reason is that if the client stands up for themselves and starts attacking back, that takes the judge out of the position of having to jump in and save the client through his orders or her orders. If the attorney steps up and you as the attorney come in and you start saving your client and you are aggressive and back, or you are aggressive toward your opposing counsel or client, the judge no longer has anything that they have to fix. And if you do it against the other side, then the judge may hop in on their side and save them. So the best thing to do is sort of take a step back, remain neutral, and allow that imbalance to happen, because the judge is then in the position of having to balance that back out.
That's so crazy, because I think if it were me feeling attacked, like your natural inclination, right, is to step up and defend yourself. But to have that awareness ahead of time that, oh, no, it's actually good that they're attacking me, that could help.
Yeah. And it also helps to bring the client's anxiety level down, because most people are afraid of that happening. And as soon as they realize that that's actually a bonus point in their favor, they sort of look forward to it. Like you almost hope
like,
that
come at me.
Yeah. Yeah.
That's funny. Yeah. I could see that being both surprising and a real kind of weight off. Like, oh yeah, okay. Not only is it okay, but it's good for me.
Yes. Now, if it gets too aggressive, there is a point at which the judge would expect you to stand up for yourself or for your client. And so it's knowing where that balance is. And I work with, attorneys and clients to sort of figure out where that would be. And you can kind of look to the judge to figure that out. But it's something that you have to feel out and that we would need to work on to figure out, it has to get fairly aggressive for you to step in.
Okay. Yeah, no, I like that. Yeah. At some point, it's not really believable anymore if you're just taking it, right?
Yeah.
So I've also heard you talk, Jessica, about how it's really important to come off as likable in court. Can you tell me what that means? Like, I want to think that we go into court and it's just about the facts. But it sounds like maybe that's not really the case all the time.
Yeah. So it's often facts are important, but the other dynamics that happen in court are equally or more so important. So humans judge everything through a story framework. Okay. And when you are in court, as the judge hears your case, he or she is taking in all those facts and the evidence one at a time, and it's creating this sort of spider web of what they think the story of the case is. But how that gets framed is impacted by each sequential fact or by the likability of the person who's presenting the fact. Okay. So if we like somebody as a human being, we want to help them out. We want to find in their favor. And so if you are a likable witness, it puts the judge in the position of wanting to find a way to legally find in your favor. So the facts that are in your favor, the judge is likely to remember and retain and to use. And the facts that are not in your favor, he or she is likely to dismiss entirely or to alter them in some way that will fit that framework. I mean, we do this all the time. I mean, that's why political discussions get so blown up, right? Because everybody sees the same facts in completely different ways because
Right.
it
It's
fits
really
what our framework is.
subconscious,
Yeah.
right? Like the
So
judge isn't doing it
can't
on
help it.
purpose.
Right. Judge can't help it as much as a juror, as much as you or I can help it. We all do it. And so the more that you can come off as likable, the more the other facts will work in your favor, or the bad facts will work less against you. The opposite is also true. If you are not a likable witness, the judge will not want to find in your favor. And so that will affect the story framework as well.
So how do people do it? Like, how do you become likable? What does it mean, you think, to be likable for the judge?
Yeah, so in this context, in a divorce context, unlikable could mean several things. It could mean that you're being dishonest and untruthful. It could mean that you are coming across as hyper anxious, bitter, defensive, all the things that most people in a divorce feel, right? So those are completely appropriate emotions. The problem is that they're not consistent with winning your case. And so we have to work through those emotions in order to make your case more winnable. And I think where the problem comes in is that attorneys will often see that. They'll say, oh, I have an unlikable client. He or she is too anxious. They talk too much. They are getting really defensive when I come at them. And so they'll tell them, stop being anxious, answer slower, take your time. And so the problem is that this can not only does it not really effectively fix the problem, because people can't do that. If they're feeling anxious, they can't not act anxious. They might for about 5 seconds and answer one question that way, but it's not going to work for the entire deposition or trial or whatever.
You can't just be like, anxiety, shut up, stop.
It doesn't work.
Yeah.
And to the contrary, it can make it worse, because if you try to tell somebody to act in a way that's inconsistent with the way that they feel, then they come off as inauthentic, which is, then we're seeing them as a liar and we don't believe a single thing that they say, which would be better to just have an anxious witness, right, than to have a lying witness.
Right.
So,
right. To be unlikable is better than being inauthentic.
Right.
Okay.
So in trying to help, a lot of times attorneys will actually make the problem a little bit worse. And so the way that we get somebody to be a likable witness who is sort of calm and grounded and confident and can own their mistakes in it, because that's important to do, but explain why that therefore does not mean that you should find against me in this order. And so the way that I do that is you have to change the internal emotional state of the client. You can't tell them don't be anxious and then talk slower. For them to talk slower, they have to not feel anxious about it. And I think that's where your work and mine sort of overlap, is you do sort of the long-term work on that with them so that in their life they feel better and can function better. And some of my work may have longer term effects, but my work is really focused on short term, just to get them focused on the specific facts of this case and this trial. And so we talk about those facts and try to find out where the anxiety is coming from. Where is the depression coming from? Why are they defensive about this fact? And so by finding out the background of it, I can often reframe how they're thinking about it, which then makes the undesirable behaviors go away, at least for a certain period of time.
No, I love that, Jessica, because I think you're right. I think there's so many parallels, right, in what we do.
Yeah.
And you're doing it for a very specific goal and a very specific time, but I would imagine it has to have a longer term impact. I like to
hope so.
Yeah, because if you start to think about something that is making you incredibly anxious or defensive about your divorce, and you can think about it in a new way, that can really stick. Can you give me an example of a reframe?
Sure. So I have a couple examples. One client had a bad fact that she didn't want to leave her child with her soon-to-be ex-husband. He was dating somebody else. She didn't approve of who that was based on what she heard from her child. And so there became this theme, though, of, you're being overly protective. Will you never hire a babysitter? And she said basically that she would only hire people that were either family or long-term friends. That's all she left her child with. And to most people, that sounds a little unreasonable. I mean, most of us leave our kids with babysitters. We interview them and maybe have a nanny cam, but you trust somebody with you, because otherwise you come off as this really overbearing person who's then, they said, well, now you're trying to, keep your child from your ex because
You're
So it became this whole,
controlling the situation.
yeah, became this whole big ordeal. And she just was not willing to waver on that. She says, my child's health and safety. And I said, I understand, but I mean, it just seems a little bit higher than most people's standards for health and safety. So as we kept talking, and I wasn't sure where this was coming from yet, you know, usually when I'm helping people, I have to start with their story somewhere. Sometimes that's way back in their childhood, because that's what made them and their parents, how they were parented. Sometimes we have to start just right from when they met their spouse. And somehow through talking this up, it came up that when she was teenage years, she and her friend went into the woods and some man came and raped them.
Oh, wow.
And so now all of a sudden, her fear of strangers and leaving her child with somebody she doesn't really know makes complete sense. So by explaining to her, you know, and all of us were teary over it, you know, that she had to find the strength to tell this story in court. And she agreed, and she did. And now all of a sudden, everything made sense. And so she could then relax sort of about why she was paranoid about those things. And she said, it's not that you can't have a girlfriend that can watch my child, but I have to meet this girlfriend. I have to know who she is. I have to get a relationship with her first because, you know, this is just my background and this is where that's coming from.
That's such a beautiful example, right, Jessica? Because in the beginning, I was like, oh, you're going to try to get this girl to change how she feels about leaving her child with somebody else. But instead, you're really just going back and where is this coming from? Let's make sense of it. Because to the court, you just seem like for no reason, you're being bossy and controlling and overbearing.
Right.
And let's tell the truth of it. And this is really where this is coming from. And anyone can empathize with her position.
Yeah. Another example is a client I had that had been cheated on by her spouse. She was an emotional mess over it. She still loved him. They had tried multiple things to make it work, and it obviously wasn't working. But she seemed like such a victim. She was very teary through the entire session. And some tears are fine, you know, that's authentic. But she was just overboard with it. And so when I, you know, heard her story, she talked about how she met him when she was a teenager in high school, and they dated, and then they got married early, and then they had a kid, and then the kid had autism, and so she's this caretaker for the child, and her life revolved around a marriage that she thought was strong and being a good wife and taking care of this child. And so when she lost the marriage, she didn't just lose a marriage, she lost who she was, because she went from being a daughter to being a wife to being a caretaker. And so she's still a caretaker, but she has nothing left. And so we had to talk through that a little bit about, you know, what are some things that you enjoy? And I had to make a list for her. She had no idea. Wow. And so had I had more time with her, you know, this was like a week before her hearing, which is why I tell people to try to back this up and do it earlier. I would have had her get into some classes and take some dance classes, take some cooking classes, because it would help her to really feel that she was her own person. And then, you know, she comes off as stronger and not so weak and hurt by this. And so even helping her figure out that that's why she was really hurt was helpful to her. And she testified a lot stronger, her attorney said, than she ever would have. But it could have been even better had we had time to really implement some of this.
Right, for her to really get a sense of a new identity that's not as a wife.
Right.
Right. So I mean, that's a great question for you, Jessica. If somebody wants support with this, when should they start? It sounds like it shouldn't be like the week before your hearing.
Yeah, it can be. I mean, I have a lot of those calls, and we do make headway with it. So there's sort of there's a push and pull with the timing issue. So my work is short term. So you can't do it months ahead and then think that you're going to be okay right before the trial. Okay. But if you don't do it far enough ahead, then certain things get locked into place. So for example, guardian ad litem appointments happen. And so somebody comes to evaluate the child in the home, and they write up this whole report. And then the attorney calls me and says, we have a horrible report. Here are all these issues. Well, the judge is likely to take that report and run with it. That's sort of what judges often do. It's already happened. Yeah. It's already happened. Or a deposition has happened and they've answered in ways that aren't favorable to them. So I prefer to get to them before all of that so that those things don't have issues, and so that we have time to implement, because often I do have people put up affirmations all over their house and have time to really internalize and read that stuff before anything happens. And if we need to implement some things like classes, then, you know, you need time to do that. So I suggest that you start early enough to do all that, but then you'll need a quick refresher before a deposition, before trial, before the guardian ad litem. So I try to get to people within about 2 days of when those things are going to happen,
Okay.
because then it's fresh in their minds. But that session doesn't have to be as long as the first session where we discover all of the background and things that happen.
Right. So like when it's the process is all starting, somebody could come to you and say, okay, I'm going to do this initial session, and then we're going to have these touch points throughout the process to help me
Correct.
show up at each moment.
Correct.
And what do you think, Jessica, is this work the most important when somebody's in a case that's going to be litigated, that's going, contested divorce, going in front of a judge? Or do you think there's a benefit for somebody who's going through mediation or trying to settle?
Yeah. There's a benefit for mediation as well. Mediators are humans too, so they have the exact same story framework. And mediators, although they are neutral, they will also push for one side or the other. If they feel like one side's being kind of unreasonable, they will stand up and push it a little bit. And so if you can come across well, then that can help in mediation.
Okay. Yeah. So even though the mediator doesn't have the power to make the decision, they definitely have the power to kind of manage the negotiation. Right?
Yeah, correct.
Okay. Well, we've already talked about some of the big changes you've seen with clients. What is like your biggest success story, do you think? And how do you think it impacted a case?
So I don't know, I don't know if one is any bigger than the other, because all these people need help, and all of them, their children are on the line and everything. One of the most memorable ones that I worked with was a gentleman who used to be a UFC fighter, and he was getting divorced, and before that he ended up paralyzed from something. And so he went from this life of being really fit and being out in the crowds and being very able to being very disabled, and relying on everybody for everything. And so then when the divorce also happened, it sort of broke him. And there were a lot of issues with the case, such as there were thousands of dollars here and there that were cash pullouts from his account that were missing. And so of course the other side is saying, you're pulling out marital money and you're using it for who knows what.
Right.
And it was a problem because you'd ask him and he had no memory of what he used these things for. But you could also see that he was sitting in a very modest to low income house. He did not have a nice car. He did a lot for his friends. If he had friends that want to start up businesses, and he would give them money to start up businesses. He had friends who wanted money to get out of a problematic situation. He would give them money. And so we had people who would testify about those sorts of things. And I said, you have to stand strong with who you are, to explain that discrepancy. And so even though there's no proof of where the income went, you can look at, his housing and his lifestyle and see that he didn't spend it on himself. And so I think that was helpful for him, as well as just learning, he felt like he was a very weak person, and who would ever want me? And why would I deserve love? And, I think it'd be hard to feel otherwise for a lot of people who are in that position. But I said, but look at how strong of a person you are. You went from this type of lifestyle to now having to live this other lifestyle and surgeries and all these other things. I said, that takes a really strong person to make it through that. So I said, just because she wasn't willing to want that doesn't mean somebody else won't. I mean, you have great character. You're a giving person. You're great. So getting him to sort of recognize that, and we did a lot of affirmations around. And his attorney said he had no idea who this guy was that showed up at the trial, that he was a completely different person, and spoke very calmly and strong and with a good internal strength that he'd never seen.
I mean, that's a really uplifting story there, Jessica, because there's somebody, it's not just about his court case anymore, right? That's about his whole future and what's possible for him going forward.
Can
you tell me why family law? Why are you bringing this work to family law, and partly why is it important to you, but why is it important for people in divorce?
So I can't figure out why my type of work hasn't penetrated family law before now. I have many colleagues, and we work in, personal injury fields and contract cases and all these other things. And that's what a lot of my work is, and still is, and always was. And I would do witness prep for plaintiffs' cases. That's sort of what my background is, that I would do focus groups, and I do opening statements and pick juries. And but nobody thought to really take the witness prep part into family law. There's a couple of us doing it, but very, very, very few. And I could not, as soon as I thought of it, I couldn't figure out why, because to me, these cases are more important even than the personal injury cases. I mean, those are about somebody who's hurt and money, and of course that matters. But this is also about money and oftentimes children. And so
it's about a family.
It's about a family, and there is nothing more important than that. So, the stakes in this, I would say, are arguably larger than even multi-billion-dollar, other cases. And to not be helping people in this arena to present the best way that they can and to find out who they really are and to make them feel better about the circumstances that they're in, and so that they can be a better parent, and so they can testify better and, not lose their child, I think is extremely important. As the attorneys have an obligation to their clients to do the best that they can and to give them the best chance that they can. And so I think they have an obligation to do effective witness prep. And attorneys in the family law arena tend to do very little witness prep, or they'll do witness prep, but they're doing the type that I mentioned earlier, where they'll try to tell the client, act this way, which I don't blame them. I mean, that's what they know how to do. And so I don't blame them. It's just, it's not effective. And so if there is this other tool out there, I feel like they have an obligation to help their clients, whenever possible, to do this.
Yeah, I mean, I think you're absolutely right? The stakes in a divorce are massive. It's your whole future, and it's the future of your kids, who are really the innocent kind of bystanders who are massively affected by the choices people make. And I do love that, not only are you helping people stay with their kids, keep their, get custody and, get the best outcome in their case, but you're also setting them up to be a better parent. You're helping them figure out, oh, that's why I'm this way with my kids. And that, like, helping them make sense of themselves. And that impact's got to be huge.
Yeah.
Was there something in particular that made you think, like, family law? Like, did something happen, or was it just come to you one day?
No, I think I talked to one of my colleagues who was doing this in family law, and I said, oh, why didn't I think of that?
That's brilliant.
Yeah.
Jessica, tell me a little bit more about your background, about your trial experience and how you got here.
So I have a JD from Duke Law School. I also have a master's from there. I went there assuming that I would get a law degree. I actually thought instead of an MA, I would be getting a MBA. Okay. My intent was always to do focus groups for products, but everybody has an MBA. And so I figured the law degree plus the MBA would be a leg up for me. And within the first semester, they did a one-day class about jury selection, which is shocking to me that it's one day now in what I do.
Is that's like it for law school? It's one day.
That was it for law school. So within that, they mentioned a man named David Ball, who, I was in North Carolina. David lives in North Carolina, and mentioned, that he was a jury consultant. And that was basically where they sort of left it, that, they do focus groups and things for legal cases, and that they can help you with jury selection. And so I looked him up and I called him. Now, David Ball, people in the family law industry probably don't know his name, but in the plaintiff's world, every attorney knows who he is. He is the national leading plaintiff's jury consultant. And so I didn't know really who he was. I just knew he was local to me. And so I had lunch with him and said, I'd love to shadow you while I'm here. And he liked me and agreed. So that was sort of my internship for 3.5 years, was, doing focus groups with him, editing opening statements. On my lunch breaks, I would go sit with him at a cafe, and he would say, come over here and watch what I'm doing. And so while everybody else did moot court or law journal, that was my training. And from there, I left law school and graduated and got my master's in psychology, and then came here and started up my own company. I've been doing this since 2008.
Wow. I mean, so you really had the opportunity right from the beginning to work with kind of one of the best consultants.
I was very lucky. Yeah. I was very lucky.
That's pretty incredible. What made you decide to get your master's in psychology?
When I spoke to David, most jury consultants don't have even a law degree. They work out of the social sciences. They have masters in psychology. David Ball actually has a PhD in theater. They work in marketing. And so instead of doing an MBA, I decided to switch over to psychology. I was a psych major in undergrad. My father is a neuropsychiatrist who's retired. And so I've been analyzed my whole life. So it seems sort of natural to me to
Yeah.
then just get the psychology degree.
Yeah, I love it. I mean, it just seems like such a beautiful fit to have the JD and the master's in
Yeah,
psychology and then all this experience coming together.
yeah.
How similar would you say what you do is to therapy? Because I mean, it sounds a little bit
Yeah.
like there's a therapy aspect.
Yeah, it's similar. I mean, I'm not a therapist. I'm not trained to be a therapist. But I have to forewarn attorneys when I start working with their client and the clients, because they're footing the bill, that the first part of what I do, whether that's an hour or 4 hours, depends on, what the budget is and how far I can go with them. It's going to sound like I'm doing nothing, because it's going to sound like chit chat. I have to find out the background story, and I don't know what I'm looking for yet. I just know that I have to know the story to find what I'm looking for, so that once I start hearing it, I can see, oh, well, that's where this is coming from. And so that we can use that to then reframe the case. So
You're
a
kind
lot
of
of
a
it is,
detective,
yeah. So it's a lot of, tell me your story. Tell me from the time you met your spouse up till now, or tell me about, how you were raised, and just sort of, I'm just a listener for quite a while. After that, we sort of work through some of this, and as we work through it, I try to create a list for people of about 5 to 7 what I call truths of their case. And so we walk through what the opposing counsel is likely to come at them with, what are the worst parts of their case. And then I will talk with the client about, so what is your response to that? What is the truth about that? Because there's probably truth in both sides, right? But we have to find the way to present it that honors that truth, but also is strong for the client. And so, for example, if you're dealing with an accusation that you're alienating your child from your spouse, one answer based on this person's specific facts was, I think it's actually very important for my child to have a relationship with her father. But when I hear of things from her that are going on over there that are unsafe, I feel an obligation as a mother to protect her. But I understand that that's a gray line I have to walk. And so I'm always trying to balance her having time with her father with making sure that she's also protected. And so I'm a human. Sometimes I may err on the wrong side of that gray line, but that's what I'm trying to do. And so, that's an answer that honors the fact that, okay, maybe sometimes I am alienating, but there's a reason for it, and that's not my intent. And so we go through some of the facts like that and create a list so that almost anything that they get hit with, they can revert back to one of those facts and feel like they are confident in their answer.
Right. Okay. So they've got, like 5 to 7 things they have to remember, but they're things that are true, that resonate, that are authentic to them. And like that example you just gave, Jessica, it sounds so humanizing. Like, I think in any discussion, but definitely in court, we tend to, kind of see somebody in a certain light, like, oh, she's the bad mother who won't let her child ever see. And the way you told it, it's like, oh yeah, that makes sense. She's a person. She messes up. It's like making it. I love. Yeah, it's the truth. It's what's really.
It's the truth.
It's the truth.
But you have to tell the truth in the right way. I mean, the client wants to say, well, I'm protecting my child because he's doing this and that to her, and this is what I hear. Well, that's not helpful. That might be true, but that's not helpful. So we can't say it that way. We need to work through this in a different way.
Yeah, you need to show up in a way that's not defensive, that's not aggressive, that's not laying blame.
Right. And this particular client had gone through a divorce with her parents. And so she hated being put in the middle. And so she honestly did not want her child alienated and did not want her child in the middle. So that's why that worked for that client, because there was truth in the fact that she did not want to alienate, but she had to protect her too.
Whereas another client might just be like, no, I really, truly don't ever want her to see that man again.
Right. And then we have to come up with a different truth. Yes.
Yeah, different truth.
Yeah.
Just if somebody is working with you, what's the commitment? Do they need to do, a 4-hour session? Can they come to you for an hour the day before they have a deposition? Like what's
the minimum I'd say is a 2-hour session. That gives me an hour to get some background information and an hour to work through some of this.
Okay.
That's pretty bare minimum. And usually what happens is we work through some of this and then it's like, okay, well, we need a whole nother session now to practice direct and cross, to make sure that this stuff actually works in practice. And so most clients end up doing a couple sessions with me. If you have the time to do it, it is helpful if I can meet with them for a longer period of time to get more of their background and to understand them more, because it will help me to come up with better ways to work through some of this. But it's all budget specific. So I'd say minimum 2 hours. Average is probably 4 to 6 hours. And then other people who have the time and the means to do it, some of them will have my phone number on hand. So when things pop up, they can immediately call me and help work through it right then and there.
Right, like
So
you've
it
got the
runs the gamut.
background, get me through
Yeah.
this. Yeah.
Yeah. So that it doesn't already solidify as something you don't want it to be.
Yeah.
So it's not lingering there for a long time till we can talk about it.
Okay. Yeah, no, I love that. That's I mean, because it sounds like you can help such a wide range of people because what you can do in a short period of time is effective, and it's definitely better than
Right.
not doing any of it at all. But if
Right.
you
I've
have,
I've had some clients that had me coach them, and then all of a sudden they want me to work on their current, girlfriend or spouse, and then they want me to work with their parents, and then they want me or their daughter. So I end up, helping a bunch of people who are going to testify.
that's interesting, right? Yeah, because it's not just the client who's got who has an effect on the outcome,
Right.
right?
Right.
That's interesting. Yeah, so you can kind of circle through all of the witnesses in the case.
Right.
Yeah, I love that. Jessica, what's the best way for people to reach out to you? How can they work with you?
Sure. They can reach me by phone or by email.
Okay.
My phone number is 303-653-2233. My email is jessica@trial, TRIAL, dynamics.net. And they can also go to my website, which is www.trialdynamics.net. On there is a small portion of it about family law. I plan on posting a video on there soon, so that will give people more information, but they can contact me through there.
Okay, perfect. I'll put all of that contact information in the video description so people can
Sounds good.
find it there too. Can people work with you? Do I have to be in Colorado to be a client? Do you work with people at all?
No, my licensing would have no effect on where I work. So I work nationwide, usually by Zoom. It's hard to meet with somebody if they're not right here, but usually over Zoom works fine, and I work with people everywhere.
Okay, that's good to know. Yeah, so it's not just a local. Can people, if people are local, do you have an office where you meet in person as well?
So I work out of my house, but I do go to their houses, or we can meet at a neutral spot.
Okay.
And I do think it's slightly more effective if I can meet with people. It depends on how they feel, with COVID and everything. I want to be respectful of everybody's comfort levels. And Zoom works just fine. We've been doing it, through the whole pandemic. So either way is fine, but I certainly do meet people in person.
Okay. Yeah, no, I mean, I love the Zoom just makes it so possible to reach people all over.
Yeah. Yeah.
Because this sounds like something that really almost everybody needs going into their worst case.
Yeah. And it helps with the attorneys too, to just figure out how to frame things. I think, they become part of the session and they learn things about their client they never knew. And so that brings up new questions that they need to be able to ask, at trial.
Right. You're not really, you're working with the client, but you're also giving the lawyer a different perspective.
Yeah.
Yeah. Jessica, what's the biggest piece of advice you would give somebody? Like, say somebody's not going to come in and get a consultant, but they want to use some of this information on their own. What would you tell somebody as they're going into this process? What should they think about?
I would say number one, try to just think about where you are stuck. Think about what are the parts that make you most angry, make you most fearful, and then see if you can find a way to reframe it yourself. I mean, for example, most people are upset that they are in a lawsuit. But if you think about it in a different way, that if you were in a different country, sometimes there are no lawsuits, right? So what's the alternative? The alternative is an eye for an eye, tooth for a tooth. Would we prefer that? Probably not. So seeing being in a lawsuit as an opportunity and a privilege can change how you feel then about being part of the process.
Okay, I like that one. That's a good reframe. Yeah, what would it be instead?
Right. And remember that everything that hasn't happened yet, everything in the future is a story, right? It's not fact yet, it's story. So oftentimes clients get caught up on, I can't send my child to him because X, Y, or Z will happen. Well, no, the story is that in the past, this has happened. And this is what you believe will happen in the future, but that's a story. It hasn't happened yet. And there's no proof that it will happen. It may never happen that way. And so I think sort of keeping that in check can help some of the anxiety levels as well.
Yeah, it's like kind of checking the inner catastrophizing.
Yeah.
right? Where your brain's like, well, I've learned this from the past. And so obviously everything is really dangerous.
Yeah.
Forward.
Yeah.
Okay, that's wonderful. Jessica, is there anything else you'd like people to know about what you do, or about what they should be doing in court?
No, I mean, I think it's just helpful for people to know that it exists. For attorneys to know that it exists, and for clients to know that it exists so they can ask their attorneys for this kind of help. You know, I know everybody that, you know, money starts flying every which way in lawsuits. And so you have to figure out where to prioritize that. And I'm not saying that I should, you know, be the priority in that, but consider it, because, you know, even if you can't afford to do it, you have to wonder, can you afford to lose? And that's, you know, that's the other way to think about it. If it were my kids, even if I couldn't afford it, I would find a way to do it, because I can't afford to lose my kids.
Right.
So, you know, and again, I'm not saying that you bring me in on every case, and hopefully attorneys can take some of this information and maybe help their own clients with it as well. But I think attorneys need to understand that there needs to be a lot more witness prep being done in a different way than what is currently happening.
Yeah, I mean, that really resonates for me, Jessica. Something I've heard from a couple lawyers lately, as far as advice, is even if it's more expensive to do it right from the beginning, do it right from the beginning, because in family law, the consequences are so drastic.
Yeah.
Right? I mean, it's your whole financial future potentially, and it's your kids. And can you afford to not do it? You know, it's even the cost up front might seem more, but then what are the consequences if it doesn't go well?
Right.
And like you said, it's, you know, it really is more than like $1 billion estate or company, right? It's your family, it's your children.
Right. And my fees are nowhere near $1 billion. So
no, I mean, well, and you're talking about 4 to 6 hours, right? It's not, you know,
even
it's not
two,
this,
if we have to, you know, something, you know, let's try to help them in some way.
Right. Yeah. So, I mean, I think it sounds like what you can help somebody, the transformation you can help somebody make, and the impact that might have relative to the investment is really, and compared to what they're already doing with legal fees and stuff, it's really not.
Correct. I mean, in the example I gave of the man who was paralyzed, that was a 2-hour prep session. So.
Wow.
Yeah.
Wow.
So,
I mean, that's huge.
Yeah. And you know, it depends on the case. Some people aren't good at giving me that background information, and we don't get as far as fast. And some people are, and it's blatantly obvious to me what the issue is. And so it sort of depends, but you know, we can at least make either something great happen in a couple hours, or at least get them somewhere.
Yeah. Right. There's like, you're not there. There's no loss, right? You're getting some degree of information that's going to affect the way you show up.
Right.
Yeah, no, and I think that the benefit too, outside of the court case, of just having, because I find this with my clients, that when they can make sense of some part of themselves that didn't make sense before, that's like just such a massive relief.
Yeah.
There's so much anxiety and resentment and anger and yeah. No, thank you so much for sharing this, Jessica. I think this is, like you said, just for people to know that this is an option and it's a place that they can get support. And like you said, you know, they're going through all of these emotions. People are bitter, they are sad, they are anxious, they are overwhelmed. And of course you are.
Right. Totally appropriate.
Totally
just
appropriate.
Not helpful.
Just not helpful.
Yeah.
Yeah. Yeah. And to have somebody who's like giving you tools to actually shift some of that, instead of just being like, stop it.
Right. Right.
Just stop it. You're like, great, I would love to stop it, but it's not that easy.
Right.
Jessica, thank you so much for joining me. It was great to have you.
Thanks very much for having me.